I thought I had the cleanup spot and that I was going to be talking about the boring law after you had heard about all of these really interesting cataloging initiatives. So my presentation will be a bit of the outlier on this panel because unlike my co-panelists this morning, I don't manage collections or exhibition or provenance work or work at an institution. I'm a lawyer in private practice, and I work with members of stakeholders in the arts industry, including on intellectual property issues and expert liability issues. So that's what I'm going to cover in brief form today, is some of the legal issues arising from the kind of work that institutions in the room, represented in the room today, are doing. It's going to be pretty surface level because I'm aware that there are not a lot of lawyers in the room, although I see some in the back. So I'll be available at lunch and on the break if you have specific questions. So again, the two main topics liability-wise I'm going to cover are expert liability and IP liability. What do I mean by expert liability? I mean problems arising from the analysis that your organization has provided of the kind of data and underlying information that some of you all are recording and digitizing and collecting. So that might include claims that you have improperly authenticated something, and I'll just note that sometimes people still try to bring that claim even when you have explicitly noted that you are not authenticating anything. It might include a claim that you have failed to authenticate something, or just generally that your analysis or conclusion about something is wrong, or that your wrongful analysis is in some way prejudicial to someone else. So we want to protect you from any of those kinds of claims, right? And I'm just going to apologize in advance for a number of corny slides of arms and armor here. I know that there's a PMA speaker here today, Katie. I went to law school in Philly, and I'm very familiar with the PMA's collection, so I took the opportunity to use some of those. The good news is that there are some proactive ways to deal with these kinds of claims by requiring users of your websites or archives or databases to ideally actively enter into agreements prior to receiving information from you, or at the very least, agree to the terms and conditions of your websites before browsing them for this kind of information. We can't preemptively fend off every lawsuit. There are always going to be frivolous claims, but these measures are a great way to reduce the number of claims asserted and also best position you if your institution has to defend this kind of claim. So we'll talk a little bit more about defenses after I break down the kinds of liability a little bit further. In terms of proactive measures, you've probably seen terms and conditions on your various institutional websites, including terms pertaining to your institution's rights with respect to its own material, which we're going to talk about at the very end of this presentation, as well as disclaimers about representations and warranties that you are or are not making with respect to the information that's on the site. So oftentimes those terms might look something like, by accessing this site, including downloading material from the site, you accept the terms and conditions. You know, by continuing to use this website, you accept the terms and conditions. As an initial matter, what makes that kind of term enforceable or not enforceable? Well, in an ideal world, you would have a user who's actively agreeing to them, super ideally through ticking a box and pressing a button. That's called a click wrap agreement. You would also provide end users with the ability to download or otherwise retain a copy of the terms and conditions on your website, and they'd be clearly drafted in plain English in addition to being conspicuously presented as legally binding. Browse wrap agreements, where a user agrees to the terms simply by continuing to browse the site, as I just mentioned a moment ago, have mixed success in terms of enforcement. So this is better than that. Zappos is an example, the shoe purchase website is an example of a site that was subject to litigation and had to redo its online terms and conditions because it was so hard to prove that users of the website were aware of them and were agreeing to be bound by them. So whether or not browse wrap terms and conditions will be enforceable can depend on how conspicuously the link to them is displayed. Is it in the footer of every single website? Is it prominently linked from the splash page, or is it something that people really have to dig through the subsites on your website to find? Another thing that's likely to give rise to a viable challenge to a browse wrap agreement is, or actually a click-through agreement as well, is if you have a term in there that requires users to accept in advance any future modifications to the terms. It's better to provide notice to users when your terms and conditions are updated. I know everyone here probably hates contracts, except for my few fellow members of the bar in the back of the room. It's not lost on me. But for those of you who aren't just passively making information on your website available, but rather you are actively providing some kind of written response to inquiries, whether it's a letter of inclusion in a catalog raisonné or something else, it's really recommended for, I should have given the disclaimer up front in this presentation. I'm not giving you all legal advice, but just as a general matter, it's recommended to have an actual written agreement specific to that process. A standalone submission agreement is going to be more enforceable in court than a click wrap, as it will, of course, have been specifically reviewed by the party who's entering into it. And it can include even more robust disclaimers, including, most importantly, the characterization of the statements that you're making as opinions rather than facts. And I'll come back to that distinction in a minute. Importantly, these kinds of agreements can also provide for indemnification, which is a fancy legal word for when someone brings a claim against you that they shouldn't have, them having to pay your expenses, which is, as Martha Stewart would say, a good thing. So allow me to present a slide that's actually a sign in my son's preschool. It's sort of funny, but it totally applies in this context of the context of work product that's issued by scholarly research organizations. We all love facts and spend a lot of our lives doing research, and we like to present things as having been thoroughly researched and authoritative. Me too. But if you haven't done so already, it's time to start thinking about your conclusions, at least within a legal framework, no matter how well researched, as opinions. Why is this important? Well, because as the preschool graphic says, a fact is something that can be proven true or false. An opinion may be asserted on the basis of expertise, good judgment, and of course your qualified research, but at the end of the day, it's your idea and your best instinct about something, not a representation and warranty that can make you legally liable. So here's a good example of a disclaimer that came from the website of an institution who's represented in the room here today. All materials on this website are provided as is, without warranty of any kind, either express or implied, including but not limited to implied warranties of merchantability or fitness for a particular purpose. At our discretion, we may discontinue or take down any or all part of the websites or remove any material. So I'm not going to bore you to death by going into the case law on this point, but suffice it to say that the issue is well established and well litigated, and artist foundations, catalog raisonné committees, and others have been found not to be liable for, the actual content of their opinion, where they have bound clients or other inquiring parties to this kind of disclaimer through a submission agreement. I actually gave a talk recently in Geneva on the underlying legal framework, the case law behind this expert liability issue. So I actually have with me a handy dandy chart of sort of what are the points that you can put in a submission agreement, what are the case laws, cases that that's based on. So if you want that to bring back to your institution to talk to your legal counsel about, feel free to ask me for it at the break. So moving on to IP, liability. What am I talking about in this context as compared to expert liability, which involves claims arising from the analysis you provide? This category of claims, which I think is what a lot more of you in the room probably are expecting to hear from me today, arises from your distribution or reproduction of underlying information. So here we might be talking about claims that you're confusing customers by copying the look or style of another provider of goods or services. That's a trade dress type claim that's much less likely to be encountered by you all. Another type of claim would be that you're improperly sharing proprietary information with third parties, that you failed to credit someone or something, or you've improperly included an image or a writing in your publication. IP claims will typically demand that you stop doing whatever you're being accused of doing wrongly immediately. And so although expert liability claims can be disruptive too, this kind of claim can also be super disruptive because it's literally like stop the presses, right? So although this slide correctly lists sort of the universe of IP claims that are out there, we're going to focus today on copyright. Again, we want to protect you. This is a shield from the PMA because I'm a nerd. The best defense is a good offense. Proactive diligence with respect to the kinds of materials that you want to use or publish. Lots of scholars and researchers want to fall back on fair use, which we will talk about in a few moments. It's a wonderful doctrine, but it's a defense, meaning that although you can take a fair use position in advance, if you're actually making this argument in response to a claim, you're sort of already in a bad place because it's a very factually specific defense. It's very costly to prove in an actual litigation. So many claims that may have a legitimate fair use defense are settled to avoid the cost of litigation. And settlements often are sort of like, okay, we'll pay you retroactively this punitive licensing fee. So some institutions where it's possible to do so will just negotiate a licensing fee and avoid this whole rigmarole of somebody asserting a claim. I know that for many of you in the room where you're talking about archives that include a lot of historic material, it's just not possible to proactively identify everything in the collection. So how can we narrow down the field of things about which we need to worry about potential infringement claims? I'm not going to, go over all kinds of diligence, but one nice thing that's sort of an easy thing to think about in the first instance is the concept of public domain, which is the category of things that were once but are no longer subject to protection. For a long time, as a result of something called the Sonny Bono Copyright Act of 1988, which is really a much longer story about Walt Disney copyrights, the cutoff for when something was old enough to be in the public domain was frozen at 1923. Then last year, after 20 years of no new material coming into the public domain, the freeze ended. And so on January 1st, 2019, the public domain cutoff got 1 year later, and things that were produced in 1924 entered the public domain. Then January 1st of this year, that happened, and now public domain is through 1925. So an easy trick is that if an artist or an author or someone whose material is included in your archive died in 1925 or earlier, then inherently whatever they produced is going to be in the public domain. You don't have to think too hard about individual items from within thereof, since they probably weren't creating things from the grave. I like to think of those folks as having graduated from copyright. And the guys on the screen are great artists and authors who died in the class of 1924 and 1925. That's Felix Vallotton, Franz Kafka, George Bellows, and Joseph Conrad. So those are some nice things to have in the public domain, right? You can also, of course, look at individual works by an artist who died later than 1924, just depending on the creation date of the work. So, for example, in 2019, important individual works by Duchamp, Kandinsky, Matisse, Klee, and Picasso all entered the public domain. With the start of 2019, we therefore have a greater selection of things that we consider fair game in an archival context. But again, many things will not be in the public domain yet, so we do have to think about fair use. It's a really complicated, multi-factor, factually specific analysis. To do fair use justice, we'd really need to spend a couple of hours. But a number of the relevant factors to fair use can really be thought about as spectrums. It's not like an easy tick box test. You really have to think about where on the spectrum your use falls. Most of the institutions represented in this room are scholarly and are making use of other people's intellectual property for educational purposes, which is likely to be transformative, is the key sort of magic legal word under the first factor, the purpose and character of your use. But just because you're a scholarly nonprofit who's making information available for an educational or scholarly use doesn't mean you're allowed to infringe with impunity. The fair use analysis also asks how much of the copyrighted work you've used. That's the third arrow down on the screen, which may be the whole thing if we're talking about a picture, but it may be less defensible if we're talking about your reproduction of a 12-volume treatise. Fair use also examines the impact that your use has on the copyright holder's market. That's the bottom arrow on the slide. Are you competing with them directly? You may not think you're competing with anyone, particularly if you're a nonprofit institution, but the not-for-profit nature of your work is not actually always dispositive, where your scholarly effort may aim to serve the same end as that of a copyright holder who is also a scholar or a publisher. Finally, and I saved this factor for last, even though it's actually the second arrow down on the screen, the fair use analysis considers the nature of the underlying work, the thing that you're using or reproducing. And as you can see from the slide, where the material is factual, your use of that information is more likely to be fair use than if you've copied a highly creative work. So you really have to think about the body of data that you're using. And I think there's going to be some discussion of this in the Q&A after, so I'll save it for that. But there are what's called a non-consumptive or non-expressive use of underlying data. And that is a good thing for archivists and people who are doing text and data, metadata and, analysis. So U.S. copyright law also doesn't recognize what we call the sweat of the brow doctrine. Just by virtue of having compiled facts, you don't necessarily have ownership of them unless you've aggregated them or compiled them in a way that employs creativity in the selection and arrangement of how you've done that. So that's the compilation context. And compilations are sort of a double-edged sword for a lot of folks in this room. Last one, that's the last one, I promise. So it means, there are going to potentially be compilation rights in some of the data that you have acquired as part of your archive, but you also benefit from the compilation copyright concept because many of you are creating your own compilations. So it's really tricky and something to discuss further, and as the day continues. While discussing the last slide, we briefly touched on the kinds of protection an institution may acquire in the ultimate work that it's putting together. So some of you are creating catalogs, which may be subject to a compilation copyright. But let's shift gears more fully into that topic and chat about outgoing licenses. What kinds of uses by third parties institutions in the room may permit with respect to the work product you're creating, meaning what are you allowing others to do with the information you all are creating? Even if you can't be sure about the ownership of rights in all of the information in your archives or collections, you can adopt a policy with respect to your own intellectual property that promotes public access and non-commercial use for research and scholarship, which I know is a shared value of many people in the room today. So lots of forward-thinking institutions, including several in this room, have adopted open access policies for their research and scholarship and or open licenses for their materials. To name a few, MFA Boston launched free high-res downloads of public domain collection objects and orphan works back in April 2016. The Met launched its open access program in February 2017 with 375,000 images of public domain permanent collection works taken by its own staff or as works made for hire, which are sort of other copyright concepts we can talk about if any of you are unfamiliar on the break. They made those things available under a Creative Commons Zero license. They provide tombstone dates for an even greater number of objects and web access to over 1,500 Met published books. Getty was an early adopter with the August 2013 launch of its open content program, providing free high-res images of public domain collection objects with embedded metadata. Since then, they've broadened the program to include digital publications, collections data, and archival finding aids, and have also launched the Getty Phototech initiative, which involves a mass digitization of 1.4 million photo archive images being subjected to computer vision for generation of item-level metadata. So I think that's stuff we're going to talk about next as well. Creative Commons licenses for images or other content are also really quite versatile with different options requiring attribution or not, allowing derivatives or not. So I actually have another handout that if you want from me on the break, you can get sort of a list of all of the different Creative Commons options to discuss internally at your institution. Even proponents of open access, however, acknowledge that there are projects for which it is more or less appropriate. And so even within those projects, specific elements may need to be restricted or by third-party rights or may just otherwise be inappropriate for open access. So it's perfectly reasonable for institutions to employ a more traditional reservation of IP rights, granting licenses to only certain kinds of users, such as other educational institutions or non-commercial use, and requiring notice or certain kinds of credit on the occasion of those uses. And in the context of an institution's own IP and unauthorized third-party uses thereof, the default copyright law, of course, works in your favor. But let's also think back to those web terms and conditions we talked about, because if you've put specific terms into your hopefully enforceable terms and conditions about third parties promising not to use your IP, then you've also put them on notice of your rights in that material, and you've created a separate breach of contract claim against somebody who infringes your property and has violated the terms and conditions in doing so. So that's another reason when you look on institutional websites, you'll often see in their terms and conditions very specific provisions about what you can and can't do with their trademarks and copyrighted material. There are any number of other kinds of liability and other interesting issues arising from the kind of work that folks in the room here today are doing. This is just some of them. I think some of these will come up in our Q&A as well, in our panel discussion. But we just don't have time to get into all of that. I'm also completely fascinated by the Ponza project that Christina talked about. So there's lots of authenticity issues that arise in this context as well. But suffice it to say that the proliferation of digital information and new technological frontiers that some of the institutions in this room today are forging give rise to myriad complicated questions of rights and obligations, but it's also a really exciting time for the arts community, the data scholarly community, and the legal community that gets to support you. So I look forward to continuing to engage in this dialogue and explore these questions with you all.